Friends, let us solve question number 3, first part, paper 1 of 2019, Advocate on Record. It says, what is the curative petition? On what grounds can a curative petition be filed? What is the procedure required to be followed for filing a curative petition? So, friends, let us dive into this answer. A curative petition is the ultimate legal remedy devised by the Supreme Court of India for reconsidering its final judgment or order even after the dismissal of the review petition. This extraordinary measure is grounded in the principle of ex debito justitia, allowing the Supreme Court to invoke its inherent and supervisory jurisdiction as the apex court of the country. The primary objective is to prevent the abuse of the process and rectify instances of gross miscarriage of justice. The Supreme Court derives this authority from Article 129 as a court of record and Article 142, which empowers it to do complete justice. The concept of curative petition is rooted in the maximum actus curiae nominant gravita, meaning an act of the court shall prejudice no one. I am repeating, the concept of curative petition is rooted in the maximum actus curiae nominum gravit, meaning an act of the court shall prejudice no one. So now let us explore its origin. The formal concept of curative petition was officially established in the case of Rupa Ashok Hura versus Ashok Hura, 2002, volume 4, SCC, at page 388. However, the foundational powers have been long existed under the maximum ex debito justitia, which seeks to prevent the abuse of judicial process and address instances of miscarriage of justice. The question raised for consideration before the Honorable Supreme Court in the Rupa Ashok Hura case were whether a final judgment of the Supreme Court can be reopened after the dismissal of a review petition. Second was whether the court possesses inherent powers to rectify gross miscarriage of justice in its own judgments or orders. Third one was what procedural mechanism, if any, should be adopted to address exceptional situations. Fourth was to what extent the principle of ex debitio justitia applies in preventing abuse of judicial process and correcting errors leading to injustice. Fifth was whether an aggrieved person is entitled to relief against a final judgment or order of the Supreme Court after dismissal of a review petition, either under Article 32 of the Constitution or otherwise. These were the issues. So, observation of the Honorable Supreme Court. In Rupa Ashok Hura versus Ashok Hura, 2002, Volume 4, SCC 388, the Honorable Supreme Court addressed whether an aggrieved person could seek relief against its final judgment or order after the dismissal of review petition. The court introduced the concept of a curative petition as an extraordinary remedy to prevent abuse of its process and cure gross miscarriage of justice. So, friends, the key concepts from the judgment are room for correction. The court emphasized that while its judgments are final, there must be a provision for correction in cases of gross miscarriage of justice. It acknowledged the need for a procedural mechanism to address such exceptional situations, leading to the evolution of curative petition. Inherent powers. The court discussed its inherent power to reconsider judgments to prevent abuse of its process and rectify gross miscarriage of justice. These powers stem from the court's status as a court of record under Article 129 and its mandate to do complete justice under Article 142. Now, coming to procedural requirements, the petitioner must demonstrate a genuine violation of natural justice or judicial bias. The petitioner must include certificate from a senior advocate confirming substantial grounds for consideration. The curative petition is to be circulated among a bench of 3 senior-most judges and the judges who passed the original judgment if available. It has limited scope. This court cautioned that curative petitions should not serve as a means for a second review. They are extraordinary remedies to be entertained only in exceptional cases where there is genuine miscarriage of justice. Deterring frivolous petitions. To discourage misuse, the court stated that petitioners filing meritless curative petitions could face penalties. This measure safeguards the sanctity of the court judgment and ensures the process is not misused. So it is balancing justice and finality. The court affirmed that curative petitions are a remedy for exceptional cases used sparingly and with caution. While preserving the finality of the judgments, this mechanism acts as a safety valve to address genuine instances of injustice. These principles collectively establish the framework for curative petitions, balancing the need for finality in judicial decisions with the imperative to prevent injustice. So this is the answer to the question. Friends, this is very important topic and this question is repeated again and again. So please grasp it thoroughly so that after examination, you may say, Rhoda, well done.